Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 243 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues we provide advice and assistance to both employers and employees. Our flagship service is our HR Harbour membership service, in which we provide ongoing support to businesses and organisations throughout the UK on all aspects of employment law for a fixed monthly fee. If you'd like to know more about our HR Harbour service and how this can help you, particularly as we go into 2026 when we have all of the new employment law rights being introduced by the Employment Rights Act 25, and you'll have all of that support and reassurance of knowing that you have us on hand to help you with unlimited advice and support. So why not get in touch for a free, no obligation quote? You can email me. My email is alison@realemploymentlawsadvice.co.uk, or you can contact our head office on 01983 897 003 and we'd be happy to arrange a call. Without further ado, I'm going to get into this week's featured content. So this episode of the podcast is the second one in a mini-series where I'm covering TUPE. So if you haven't already listened back to the previous episode, I did cover what TUPE is and the circumstances in which it applies. So when we talk about TUPE, we're talking about the Transfer of Undertakings regulations, which provide protection to employees in relation to the transfer of their employment, either on a business transfer or a service provision change. And in the previous episode, I explored the circumstances in which TUPE applies. In this week's episode, I'm going to talk to you about employee rights under TUPE and how this would affect you if you have employees who are transferring in or transferring out of your business or organisation. Now, the main fundamental right in relation to TUPE is the right to automatically transfer to the new employer. So in circumstances in which TUPE applies, if the employee falls into the organised grouping of employees that would transfer over with the entity or the business or the service provision that's being transferred, then their employment will automatically transfer. In order for their employment to automatically transfer, then the following requirements are essential. The first thing is they must be employees of the transferor. So they must be employees. They can't be consultants or self-employed persons. They must be employees. They must have been employed immediately before the transfer or deemed to be so employed. So if somebody is dismissed for a reason relating to the transfer immediately before the transfer, then they are deemed to have been employed. But it's really critical that they are actually an employee before the transfer takes place. They have to be assigned to the organised grouping of resources or employees that is subject to the relevant transfer. So it can't just be any employee of your organisation. It has to be those that are assigned to that particular area or resource. And critically, in order to transfer, the employee must not object to the transfer. So an employee doesn't have to transfer over if they don't want to. However, if they object to the transfer and they fall within the organised grouping that would transfer otherwise, but for their objection, then their employment will end. So you can't force someone to change employers, but then there would be no obligation on the transferor to retain them in their employment if they object to the transfer. And finally, their contract of employment must otherwise have been terminated by the transfer. So if TUPE rules didn't apply, would their employment contract have otherwise been terminated? So those are the key requirements for an employee to transfer and for the automatic right to transfer to apply to them. Now, when it comes to looking at whether somebody is assigned to an organised grouping of employees, as you can imagine, this has been something that has been litigated fairly heavily because circumstances are that typically the transferee objects to an individual or individuals from transferring to their employment on the basis that they are not assigned to the organised grouping. As you can imagine, sometimes it's not in the best interest of the transferee to have to take on those employees, and so they will try to argue otherwise. So there has been a lot of litigation on this point. And unfortunately, there is no clear definition of what is meant by assigned, other than to state that it is other than on a temporary basis. So they can't be assigned to an organised grouping if it's a temporary basis. But as you can imagine, without a firm definition, it has been down to the courts and tribunals to decide on whether a person is assigned to that organised grouping. And there have been lots of European cases on this as well, because obviously TUPE is fundamentally a European law, and therefore there has been lots of decisions of the European Court of Justice. And ultimately, when you're just trying to decide if an employee is assigned to that organised grouping, it's a question of fact. So it's a factual question which takes into account a large number of factors, including one of which could be the percentage of time spent working in the undertaking that's being transferred. And unfortunately, again, in relation to the percentage of time that somebody spends working on a particular area of the business, there is no specific percentage of time that you can say with certainty would mean that they are assigned to it. So whilst in some cases somebody may spend the majority of their time or a large percentage of their time working on that area of the business, and then the courts or tribunals could determine that they still aren't assigned to that grouping, versus another situation where they may have much less time. So just by way of illustration, there's a couple of cases I want to reference for you. The first one is CPL Distribution Limited versus Todd from 2003. And this is a Court of Appeal case in which the Court of Appeal confirmed that an employee was not assigned to the part of the business which transferred, despite the fact that most of her work related to the contract which transferred. In this situation, the employee, Ms. Todd, worked as a PA to a manager who had little or no connection with the part of the business that actually did transfer. So neither he nor his PA were assigned to the part that transferred, despite the fact that most of her work that she did related to the contract that transferred, because her job was as PA to a manager who wasn't assigned or connected with that. She wouldn't transfer with the business when it transferred to the new provider. And then in another case, which is Skill-Based Services Limited versus King from 2005, the Court of Sessions held that time spent working on a particular project was only one factor to consider in determining whether an employee was assigned to that project when it transferred under TUPE. And therefore, of two employees spending 80% of their time on that project, the tribunal had not made an error in deciding that only one of them transferred under TUPE. So again, you can see why it can be difficult for employers to determine, and why there can be a fair amount of dispute in relation to whether an employee or particular employees do transfer over. And there have also been some cases that have arisen where employees have been splitting their time between areas of the business and only part of their job role transfers over. And in those circumstances, again, it has been ruled that that part of their employment can transfer, and effect they would then have two part-time roles with two different employers, so the transferor and the transferee. Now, it's been noted that this may not be practical, and in those cases it could be possible for employers to make a change based on showing that they have an exception to the rule that says you can't make changes if it's related to the transfer, which I'll come to talk about later on. I mentioned earlier when we were talking about the criteria for determining whether somebody would be assigned to an organised grouping is that they mustn't be dealing with it on a temporary basis. So somebody who's temporarily assigned to an organised grouping would not normally transfer under TUPE. And so if they've just been seconded or they're doing some additional work as part of their normal job role, if that's a temporary arrangement, then typically they wouldn't transfer over. They would just remain with their existing employer. Another question that often arises in relation to determining whether somebody would automatically transfer is whether somebody who is absent at the time of the transfer would actually transfer over. And again, as you can imagine, there have been several cases on this, including a case from the Court of Appeal in 2004, when it was confirmed that, in essence, the decision about whether somebody should transfer when they're absent is a matter of fact. And so the employment tribunal should determine whether they are an employee who is required to work immediately before the transfer on that particular area of the business. So in this case, which is the Fairhurst Ward Abbots Limited versus Boats Building Limited from 2004, it involved an employee who was on long-term sick leave. And in that case, the tribunal had made an error in finding that the employee had not transferred. The fact was that they would otherwise have been required to work on that area of the business before the transfer, and therefore the fact that they were on long-term sick leave didn't make any difference, so they would transfer over. And in another case, which is Jackaloo versus Nesta Prime Care Services Limited, an employee who had been suspended pending a disciplinary had been